Good evening, everyone. ILI Kerala State Unit cordially welcomes honorable judges, senior advocates, members of Executive Council of ILI, President, Secretary of High Court Advocates Association, members of Bar, honorable guests, students, and all those present this evening. In every criminal trial, appreciation of evidence is of paramount importance. A single contradiction or omission in a testimony of a witness can often become the turning point in a case. Understanding when such contradictions and omissions are material and how they influence the outcome of a trial is an essential skill for every legal practitioner. Today's session on understanding contradiction and omission in criminal evidence promises to provide valuable practical insight into vital aspect of criminal law. Before we commence today's session, I would like to invite Advocate Mida Sudhindran to deliver the introductory address.
In criminal trials, the truth is rarely presented in a continuous, flawless narrative. Human memory is imperfect, perception is subjective, and expression is often incomplete. The law must account for these realities, which is why the distinction between an omission and a contradiction is one of the enduring nuances of criminal law. The law logically does not expect perfect consistency in testimony. Witnesses may forget details like dates and numbers, recall events differently, or even deliberately alter their accounts. That's exactly where cross-examination comes in. Trial lawyers, use cross-examination as a tool to distinguish between natural human error and material discrepancies which undermine the very credibility of a witness. And two of the most important concepts in this process are contradictions and omissions. While both relate to inconsistencies in witness statements, they are not synonymous. I always use a simple factual scenario to distinguish the two. Suppose a witness gives a statement to the police immediately after an incident. He says, "I saw Lionel Messi hit the shopkeeper and run away." But when he comes to trial, he says, "I saw Lamine Yamal hit the shopkeeper and run away." These two sets of statements, there would be a contradiction because the witness made two statements that cannot both together be true. In other words, the later statement directly negates the earlier one. But consider a different set of statements. "I saw Lionel Messi hit the shopkeeper and run away." But when he comes to trial, he says, "I saw Lionel Messi hit the shopkeeper and run away with a big bag." Here, the witness has omitted mention of the big bag. Now, whether this omission would become a contradiction depends on its significance in the factual circumstances and is dependent on multiple variables. So suppose if it's a case where the prosecution is alleging robbery, then the omission may be treated as a contradiction because the person who truly witnessed the incident would have mentioned such a big bag at the first and earliest opportunity. But on the other hand, if the prosecution case is just hurt or even grievous hurt, then the omitted fact may not be significant and does not affect the credibility of the witness. Now, on the surface, these concepts seem simple, but not so in practice, which is why we are all here this evening to learn from an expert. Today's lecture will help us unravel the legal principles governing contradictions and omissions in previous statements and the procedural requirements to prove them during a trial. Thank you.
Thank you, Mida, for your introductory address. Today, we are privileged to have with us Advocate John S. Ralph, a highly reputed defense lawyer who has been in active legal practice for the past 35 years. Advocate John S. Ralph conducted numerous defense trials across the state and is widely respected for his courtroom advocacy and expertise in criminal law. He is a prolific legal author with over 70 publications and numerous reported judgments to his credit. His writings span a wide range of criminal law topics, and he is a regular contributor to KHC and KLG. Apart from a distinguished legal career, Advocate John S. Ralph is also an accomplished sportsman with an impressive track record in cycling and shooting. He has been honored by the National Rifle Association of India with the title Renowned Shooter. I now invite Advocate John S. Ralph to deliver today's session on understanding contradiction and omission in criminal evidence. So before we start the session, I would request all the participants to post the questions related to the session in the chat box. So over to you, sir.
Thank you, Akhil and Neeta, for the introduction. And the subject today is contradictions and omissions. It is a dry subject for those who are not familiar with the trial, especially in the criminal trial, and it's a very live subject for the practitioners on the criminal side. And the introduction given by Neeta was to the point. That explains everything as far as contradictions and omissions amounting to contradiction. So before we go to that, let us see what is the other aspect, that is corroboration. So let us see what is corroboration, then we'll come to the impact of contradiction and how to prove it and what is the practical side of that. So section 134 of the Evidence Act, because it's interwoven in most of the sections are in the Indian Evidence Act, and some sections are in the CRPC. And I'll be referring to Indian Evidence Act because I'm not familiar with the sections of BNSS. So I'm very comfortable, or I'm more comfortable with BNSS and Indian Evidence Act and CRPC rather than BNSS and BSA. So I'll be referring to the sections in Indian Evidence Act and CRPC. So if you want, you may follow the other statutes. So 134 of the Indian Evidence Act says that no number of witnesses are required for the proof of any fact. In other words, it says that corroboration is not a rule of law. If there is corroboration, it is well and good. So even without corroboration, a fact can be proved. That does not mean that a case can be proved without any corroboration. That's a different aspect. 134 speaks about a fact. So for the proof of one fact, only a single witness is necessary, which means there is no need for any corroboration. But there are situations in which statute mandates that there should be corroborations. In other words, some sections deal with only with corroborative evidence, not with substantive evidence. For example, section 34. Section 34 of the Evidence Act deals with the books of accounts. That is only a corroborative piece. That alone cannot substantiate a case or a fact. So that is a corroborative fact. And section 157 says that the previous statement of a witness or previous statements regarding a fact, those are only corroborative pieces of evidence. So that alone cannot prove a fact. And other aspects which specifically mentioned in the statute is accomplice evidence. 114B says that an accomplice is unworthy of credit unless corroborated on material particulars. That is specific statutory provision. And another aspect which needs corroboration is the testimony of an approver, which is, the confessing accused, which is retracted. The accused has confessed before the magistrate or the judiciary, and subsequently suppose he is retracting that confession. That requires corroboration before acting upon that set of evidence. That is mentioned in 2011 Supreme Court 2778. So that is a judge-made law. Unfortunately, that has not been taken care in the BSA 2023. That ought to have been in the amended sections of the law. That has not been done. So these are the situations which mandates corroboration. In all other aspects of facts, no corroboration is required by the statute. And there are, on a caution, courts always look for corroboration. Because if there is no corroboration, a single lying witness can create a case or end in a conviction. So that is why the courts always look for corroboration. Not that witness cannot be believed. The prosecution can manipulate an entire case on the basis of a single witness. That is the danger of not looking for corroboration. So this is the basic principles of corroboration. And now, what are the methods in which corroboration can be done? First method is through the statement of another witness on the same aspect, on the same point. There is no specific provision law which says that it can corroborate. That is a common practice. That is a common law on practice. That is just nothing but common sense. And this establishes or more veracity to the statement of that particular witness. Another circumstance, another section of law that deals with corroboration is corroboration through circumstances. That is mentioned in section 156. For example, the person says that that's the place of incident, and on my way, I fill petrol from a petrol pump. I withdrawn some cash from an ATM. So, in order to corroborate those facts, he can prove, or the prosecution can prove, the CCTV in the petrol pump, or the payment made at the petrol pump, or the ATM withdrawal done at the ATM counter. So all these facts, all these corroborating facts will corroborate the statement of the witness or the victim that he had gone to this place or he was there at that particular moment of time. And that assumes importance by why? Because only if that person or that victim is at that moment at that place, then only he can either be a victim or he can be a witness. So that is an occasion coming under section 7 of the Derivatives Act. So all these are interrelated. As you know, almost all the provisions, maybe except 167, all the provisions in the Evidence Act are interconnected. And there is a logical, not logical, the philosophical continuity from section 1 to section 166. So each and every aspect is interrelated. So this is a statutory provision which recognizes corroboration through establishing another facts. And the next one is corroboration by his own statement. So the contradictions and omissions, we are dealing with this aspect of corroboration, the contra aspect of the corroboration of one's own statement. And so that is mentioned in section 157. And it can be two types: a statement by a witness or a statement by the injured or the complainant or the first informant. So there are slight variations, these types of witnesses. If the victim is the person who is giving the 154 statement, namely the FIS, then that statement can be used for the purpose of corroborating a subsequent testimony before the court. But suppose the injured is not the person who is giving FIS. FIS has been given by some other person that ended in registration of an FIR. And if the police is taking the statement of the victim subsequently, then that statement becomes a statement given by the witness during the course of investigation. So that statement cannot be used for the purpose of corroboration. We'll come to that point later. I'm just saying what is the difference between the de facto complainant giving the FIS or the de facto complainant or the victim giving police statement after the registration of FIR. We'll come to that later. Then these previous statements applies or gives consistency, not veracity. The other things, other corroborations, corroboration by the statement of another witness, corroboration by circumstances, etc., goes to the veracity of the statement. But corroboration by his own previous statement gives only consistency, not veracity. If a person is lying, he may be lying again and again. That does not mean that he's a person with veracity. But at the same time, that will show his consistency. So he may be consistently lying. So that is the difference between consistency and veracity. So if a witness is corroborating by his own previous statement, that does not give him veracity, that gives him consistency. And why consistency is important? If a person is inconsistent, no one will believe him. Just take for the example of a politician or a minister. If that person is inconsistent in his statements, nobody will believe him. Nobody will vote for him. So that is a very basic common sense. So the witness should be consistent. And this consistency starts from observation. A witness is having three duties or three aspects in his testimony. At a given point of time, say for example, an assault is taking place, a witness or a victim, that person observes something. That is his observation. And whatever he has observed, he is recollecting before the police officer. So that is the statement to a police officer. And whatever he recollected before the police officer, he has to reproduce before the court of law. So that is testimony. So he should be consistent in his previous statement and his evidence before the court. So this is the fundamental of consistency. And why the other statement of the police is not treated as substantive evidence, that is solely for the purpose of corroboration only in certain circumstances. Because often a question comes whether the FIS given by a person who is no more can be treated as substantive evidence. That cannot be. Even if it is given by a victim, that cannot be used as a substantive evidence unless it is a dying declaration. Why? Because that statement is not on oath. It is not tested in cross-examination, and that is an out-of-court statement, which has to be treated as hearsay. So that is the relevance or impact of a previous statement. But if the previous statement given to a police officer or during the course of investigation or even as a FIS, if that amounts to a dying declaration, then that can be used for the purpose of corroboration. Statement can be used for corroboration. But statement are subject to the limitations mentioned in section 160. We'll come to that. So this is the importance of recording previous statement by the police. So the court has to see whether this person was consistent right from this police statement. So whatever he has observed, he has to recollect before the police in the form of a statement, and then he has to reproduce it before the court as a deposition or testimony. If all these are consistent, then the court will believe it. So it is for that purpose police statements are recorded during the course of an investigation. So the primary thing. And another importance or use of this previous statement is that will give the defense an idea on what is this witness is going to depose before the court. So that will have all those statements will have some basic introduction regarding the witness, his education, qualification, his family life, his position life, etc., etc., and then only starts the narrative. So the defense will get an idea on the basic facts which is going to be deposed by the witness. So that is one purpose of recording this police statement. Another thing is that, am I audible?
Yes, sir.
Yes,
A
sir.
little louder, if possible.
Yes, sir, you're audible. You're audible.
Another aspect is that on a later stage, the defense should not say that this person had never given statement before the police and he is coming to the court for the first time. If there is no previous statement, the defense can say so. So in order to avoid that, the police has to record a statement to show that this person was available throughout the investigation. So that is another use of recording. And one more aspect is there, which is not very well used in Indian law. Another aspect is that in order to avoid the defense of alibi, statement of relatives or friends or who are around the accused will be recorded by the police. And that is also being done in Indian law, Indian jurisprudence of criminal procedure. But in some other countries, that is mandatory in order to avoid a defense being taken on a subsequent stage. In many countries, if the defense want to take up alibi, the defense has to say it at the initial point of time, so that the prosecution will start by adducing evidence to show that accused was at or near the place of occurrence. So we don't have such a hard and fast rule in India. But for that purpose also, the police will record the statement and produce it before the court, especially from the relatives. They may not be examining those relatives, but they will record the statement to prevent the subsequent taking up of surprise defense of ADV. So these are the practical use of recording police records beforehand. Now we'll see what is the effect or in what manner it can be used. So section 160 gives powers to the police officer to call any witness, any person acquainted with the facts of the case, and his statement will be recorded. So the accused person will be the best person who is acquainted with the facts of the case. So his statement also will come under the purview of section 161 or 162. Because some judgments refers to 161 statement, some judgments will be referring to 162 statement, both are same. So 161 gives us protection to the accused for withholding statements which is against him. So any person summoned by the police can withhold statements which is against him. So that is not a per se, that is not a constitutional protection coming under from Article 20 Clause 3. We were having that protection right from 1872. And when the CRPC was redrafted in 1898, the same protection was there. And we were having Code Napoleon. Napoleon drafted all these codes. CRPC was the brainchild of Napoleon. So we were enjoying that self-incrimination right from 1872. That was guaranteed in 1898, and subsequently Article 20 Clause 3, then 1973, now BNSS 2023. So that protection is always there. So barring that, all the witnesses have to tell the truth, including the accused. But he cannot be compelled, he can withhold. He can withhold which answers which is damaging to his own interest. But at the same time, if a confession distinctly relates to the discovery of any fact, that fact can be used by the prosecution under section 27. So the use of the statement of the accused for the purpose of discoveries under section 27 is also protected. So statement of witnesses can be used for the purpose of corroboration on two aspects. One, dying declaration, as I already mentioned. Two, section 27 discovery. So that their statement comes from the accused. Accused is also a person who can be summoned by the police under section 160 and whose statement can be recorded by the police under 161, and the use is mentioned in section 162. 162 says that a statement can be used only for the purpose of contradiction, except in two situations. That is Article 30, section 32(1), that is dying declaration, and section 27, discovery of discovery from the confession. So these two aspects are saved, and this 32(1) was there right from 1898. Section 27 saving was not there. And in 1939 Privy Council, Pakala Narayana Swami Privy Council took a stand that any confession made to a police officer is hit by section 162. So that cannot be used. So in Act 15 of 1941, if I remember correctly, Act 15 of 1941 introduced section 27 as an exception in section to the bar contained under section 162. So after 1941, that is also permissible. There is no hit from section 162. So this is the basic idea of section 162. So the statements given before the police officer can be used only for the purpose of contradiction, except in two situations, that is dying declaration and section 27 discovery. This is the rule. And other statements recorded by the police in the course of investigation. 154 FIS. So that can be used for the purpose of corroboration. Why? Because that is given before the investigation starts. So bar comes once the investigation starts. So 154 is the starting point of investigation, and which is the statement is given before the starting of the investigation, so that can be used for the purpose of corroboration. Another set of corroborative statement is 164 statement. So 164 statements are given before the magistrate. That is not a statement to the police officer. So that can be used for the purpose of corroboration. Then statements given to the magistrate during the test identification period. That also can be used for the purpose of corroboration. And these statements, though that TA parade are being sponsored by the police officers, the statements are, or the parade is being conducted by the judicial officer. So that statement can be used for the purpose of corroboration. And other statements, there is a bar, and the 157 speaks about the statement to authorities. So the statement given to the police officer is, there is a bar, but at the same time, statements given to magistrate, there is no bar. And statement given to or statements made to other persons, that also can be used for the purpose of corroboration through the examination of those witnesses. And so this is the way in which the prosecution can show the consistency. And if there is no consistency, then the credit of the witness will go. So witness should be consistent from the observation at the place of occurrence, recollection at the police before the police officer, reproducing before the court of law. So there is if these statements are not consistent, then the credit goes. So this is specifically mentioned as one of the methods in 155.3 of the Indian Evidence Act. There are so many methods in teaching the credit of the witness. Say, for example, character assassination, testing the veracity of the witness, testing the memory of the witness, attacking the impartiality of the witness, showing that the witness is tutored, showing that the witness was not at the place of occurrence of alibi of the witness, etc., etc. So many methods are there for showing that the witness is not worthy of credit. But our subject is contradiction and omission, that is specifically mentioned in section 155.3 of the Indian Evidence Act. Section 155 deals with three aspects. One, that the witness is not, by examining another person and saying that this witness is not a trustworthy person. That practice is not followed in India because we don't have any proper perjury laws. So any witness can come to the court and depose anything. So the courts will not entertain another witness coming to the court and say that this witness is not worthy of credit. So that is being practiced in some other countries where they have very strong rule against perjury. So in India, we don't have such a practice. And another method, 158.2 speaks about the method through which a witness credit can be impeached if it can be shown that the witness has been bribed or has offered the acceptance of the offer of bribe, accepted an offer of bribe. And that is being practiced in India. Usually at the end of the cross-examination, there will be a question to the witness. In the form, you are speaking at the influence of the police, or you are speaking at for and on behalf of the victim, etc., etc. So that is the number 2 mentioned. 155.2 speaks about that method. 155.3 is the subject of our present day's lecture. That is the proof of contradictory statements. 155.3 speaks about two aspects, statement and evidence. The word statement refers to the previous statement. It can be for the police officer. It can be before any other authority. It can be to any person. It can be in an interview. It can be a letter, anything. If that statement is not consistent with the evidence before the court, then the credit of the witness goes. So there lies the promise of the cross-examiner to bring out these contradictions and certain omissions, like Mita said in the introduction. There are omissions which may affect the truth of the statement. That depends upon the situation. So, what is the method of impeaching the credit? So, usually the cross-examiner can start the cross-examination without referring to the previous statement. And subsequently, if he wanted to contradict that witness with his previous statement, then that previous statement has to be put to the witness. So this is the sum and substance of section 162. So 162 specifically says that if the cross-examiner wanted to contradict the witness through his previous statement, then his attention has to be drawn to the previous statement. So there was no statutory compulsion for invoking section 145 of the Evidence Act before 1923. There was no such mentioning of section 123 of section 145 in section 162. So after 1923, section 162 was amended by adding the word 145 of the Indian Evidence Act. So before that, the practice was that the defense can, through other methods, prove the contradiction. Say, for example, if the witness has made a different police statement, then they could have produced the statement without confronting the witness and say that, see, there is a police statement which is contradictory. But after 1923, that practice cannot be done. So the witness should be given a chance for explaining the contradiction. So this is the 1923 amendment, and that was influenced by the 1915 Privy Council, page 7, Bal Gangadhar Tilak's case. And this was reiterated in 1966 in Bharat Singh, 1966, page 405 AAR, and that was followed in 1974 Supreme Court 711 by Justice V.R. Krishna, one of the most beautiful judgments on the aspect. So this is the historical reason or the chronology of events that ended in the present form of section 162. So the cross-examiner will start. The Mida has given 2 examples. Suppose in the first example, suppose before the police, the version was A stabbed B. And in the court, the witness says A stabbed V. Before that is the police statement. In the court, he says B stabbed V. So these statements are contradictory. So the police statement refers to A. The court statement or the deposition before the court or the evidence speaks about the presence of B. So these statements are contradictory. So the cross-examiner will bring out the facts before introducing this statement, police statement, for the purpose of contradiction. And after that, the statement before the police will be put to him. For example, he will be asking you, do you know, have you seen the incident? Very clearly, yes, I have seen it. Have you seen somebody stabbing V? Yes, I have seen it. Do you know this person? Do you know B? Yes, I know B. After making all these questions, this is called the preparatory questions, or we call it brick building. After that, the contradictory statement will be put to the witness. Have you stated before the police that it was A who stabbed? Then obviously he will say, no, I have not stated so. So then the point of contradiction starts there. So the police statement was to the effect that it was A who stabbed. Now the police, the deposition before the court, the evidence before the court is to the effect that it was B who stabbed. So these statements are contradictory. So one diction will negativate the other diction. So that is contradictions. The diction that A stabbed is contrary to the diction that B stabbed. So these 2 dictions will not go together. That is contradiction. So this is the sum and substance of the way in which the witness is being contradicted. Now the problem for the cross-examiner is that there may be situations in which the cross-examiner need not contradict the witness. So that is the impact or effect of section 145. 145, the Evidence Act is having two limbs. First limb of cross-examination can be done without referring to the statement before the police. So that will give the substantive, that is called the substantive effect of cross-examination. The second limb refers to contradiction. If the cross-examiner wanted to contradict the witness, then his previous statement has to be read and put to the witness, and he should be given a chance to explain it. So if the cross-examiner goes to the second part, then he will get the contradictory effect. And the effect of that contradiction depends on the facts of the case. Like Mida said, in the statement, in the second statement, the second situation she mentioned, there is a mentioning about a bag. And if that bag is having some relevance, then only that contradiction is having a relevance, or there is no relevance at all. So all these contradictions or omissions depends upon the situation in which that occurred. So the cross-examiner can, without referring to the previous statement, goes on cross-examining, and he wanted to contradict that witness, then his previous statement has to be read. So on the practical side, it is at times it is very difficult to decide whether to contradict or not. I will tell you just one example in which we are conducting a case in Malabar. There is a brutal assault in which multiple injuries were inflicted on the victim with a long knife. They call it Madawal. Malabar side, they call it Madawal. And that is having one blunted long knife with a curve on at the end. So it's a long weapon. So multiple types of injuries can be caused with this Madawal. So the police, in fact, the police planted a weapon for the purpose of secondary discovery. They planted it because they could not find out the weapon because that weapon was destroyed. So they planted a weapon. And fortunately for the defense, they have shown this weapon to the doctor who treated the victim and took a certificate from the doctor and a statement also. So in that statement, doctor said, with this portion of the weapon, this injury number so and so can be caused. With this portion of the weapon, injury number so and so can be caused, etc., etc. Fortunately for the defense, that weapon was shown to the doctor and a certificate was also issued by the doctor. Apart from his statement, he has also issued a certificate, a document like certificate. Whether it is hit by the section 160 is a different matter. Anyway, doctor has issued a certificate. That certificate was dated wrongly. For example, suppose the alleged recovery or discovery from the accused was on 29th. Fortunately for the defense, the doctor's statement was dated 28th, the previous day. So police officer has already procured the weapon, has shown to the doctor, took his opinion whether this weapon can cause such and such injury. He made sure that it can. After that, he planted that weapon with a date on the next day. Obviously, it was a mistake committed by the doctor by putting the date in that certificate. And the doctor's statement was recorded by crime branch, another DSP subsequently. So doctor gave the statement in tune with his own certificate. The police officer who recorded the statement of the doctor did not get it, that the mistake committed by the previous officer. So the document would show that. Document and the doctor's statement would show that. That was, for example, that was given to the doctor for the purpose of verification on 28th. And the recovery or the discovery through the accused was on the next day, 29th. So this document was not supplied to us, but we were having the statement of the doctor. So this document was produced by the prosecution and marked in trial during the examination of the doctor. We were not aware that such a document was there, the certificate was there. Immediately we found that that certificate was predated. And that was also in the statement of the doctor, the statement on the date on which he prepared the document. So we have a method. We can choose whether to put that to the witness to show that this was created before it was recovered by the police, allegedly recovered by the police on 29th. But at the same time, there is a risk. If the prosecutor is so vigilant, he will get it and he may clarify it in the re-examination. So the moment the certificate was produced and marked at the end of the examination of the doctor, many lawyers were there on the defense. So we have immediately decided not to cross. So we have said no cross. So that is the practical difficulty. So we may try to cross because no cross is also having some danger. Because if the prosecutor is very vigilant, he may sense it and he may realize that there is a mistake and he may clarify it with the doctor. So many risks are there, but at the point of time, we have decided not to cross. And subsequently, during the final hearing, we have pointed out this to the court and we were able to establish that this recovery was a planted recovery and that was taken before the alleged recovery being made from the accused, and that was given to the doctor, and after getting the confirmation from the doctor, they have planted it. So this type of cross-examination, because now cross is also cross, this type of cross-examination is referred in the first part of section 145. So we could have also cross-examined the doctor on the other aspects on this certificate. We can make sure that the certificate was authored by him, just to make sure that he will not depart in the re-examination. So from that cross-examination, the cross-examiner will get an advantageous situation in the sense that he will be able to tell the court that this weapon was planted. And before it was allegedly recovered, it was shown to the doctor. So that is the first part. But at the same time, we can show the inconsistency, if any, in the police statement. So if you go to the inconsistency, that part of that inconsistent portion can be used for the purpose of clarification by the prosecutor. So prosecutor may clarify it if the prosecutor is vigilant. So this is the practical difficulty of the cross-examiner. He has to decide whether to stop the cross-examination the moment he got the favorable answers or to go with the contradictions. If the cross-examination goes to the next part by using the contradictory effect, or if you want to take the advantage of the contradictory part, then the prosecutor is also entitled to clarify those statements with the police statement, with the same witness. So that is the practical difficulty for the defense lawyer. So we have to decide whether to end at the first part of the cross-examination or to go to the contradiction. So this is the method, this is the practical side of the cross-examiners bringing out the contradictions. So at all time, the cross-examiner need not go to the aspect of contradictions. If he is satisfied with the substantive effect of the cross-examination, and if he could elicit advantageous situations from the witness, then he need not go to the contradictory part. So the risk is that if you go to the contradictory part, witness can clarify, prosecutor can clarify, even the judge can clarify. So this is the practical difficulty or the most crucial aspect of the cross-examiner's techniques or tactics at the time of cross-examination on the floor. And so I think now we have got some idea regarding how to prove the contradiction. Now the second part is with regard to the omissions. And there are omissions which may amount to contradiction. Like in the case Mita mentioned, if it is a case of robbery, and if the witness has not spoken regarding the presence of bag, then that assumes importance. Now, this was not in the statute before 1959. So the 59 Supreme Court 1012, that was still considered to be the locus classicus on this aspect of omission. Tahsildar Singh's case. In Tahsildar Singh's case, this was the issue. whether an omission will amount to contradiction, whether the court below was right in rejecting certain questions through which the defense lawyer wanted to bring some certain omissions. The court did not allow that. That came before the Supreme Court in appeal, and the Supreme Court said that those omissions, the way in which the trial judge refused those omissions was perfect, because there was no provision for bringing an omission. So with that, subsequently it was inserted in section 162(2). I'm sorry, explanation. An explanation was introduced subsequently, and explanation says, I'll read that explanation. Explanation to 162. An omission to state a fact or circumstance in the statement referred to in subsection 1 may amount to a contradiction if the same appears to be significant and otherwise relevant, having regard to the context in which such omission occurs, and whether any omission amounts to contradiction in the particular context shall be a question of fact. So that is the explanation given to section 162. So there may be omissions, but all omissions are not contradictions. If an omission is significant and is relevant, then that omission will be treated as a contradiction. Suppose in the example we mentioned just before, suppose the witness omitted to say about the presence of the bag in the case of robbery. So had he really seen the incident, he would have necessarily stated about the presence of the bag. He has not stated so. So that will be treated as an omission, because that was a crucial aspect which he ought to have been stated to the police. So with this explanation, in Indian law, we can bring out omissions also if it is significant and relevant regarding the facts of the case, when it is applied to the facts of the case. So this was the impact of section 1959 Supreme Court 1012. Before that, there was no such rule. So obviously 59 Supreme Court was referring to or were relying 1933 Madras 372, Ponnusami Chettiar. In Ponnusami Chettiar, Justice Burns said, there cannot be an omission which will amount to contradiction, because silence, omission is silence. A silence cannot be a diction. So if the witness is silent on an aspect, there is no diction. So if there is no diction, there cannot be a contradiction. So this is the way in which we have introduced this explanation. And whether it also has to be put to the witness before acting upon that omission is another aspect. Just like the contradiction, the witness should be given a chance to answer the omission also. For example, in the statement, suppose the witness has not spoken about the bag, then witness has to be asked, have you stated that the victim was having a bag with him? Then he should be able to give an answer. He may say that was a small purse, I could not see that at that point of time, or there was insufficient light, so I could not see that. So if that explanation is possible, that applies also to contradictions. If that explanation is possible, then his credit will not go. So this is the rule. If the cross-examiner wants to discredit the witness, that aspect has to be put to the witness, and the witness should be given an opportunity to explain. And this is having a very interesting history of adding this section. So in 1820, George IV wanted a decree against Queen Caroline for alleging adultery against her. So he moved the parliament. At that time, parliament can take evidence and they can decide through a resolution. So King George IV moved the parliament, and witnesses were examined before the parliament, and certain questions for discrediting the witness were put. But that was not permitted. because those statements were not produced. So the parliament said that maybe there may be some jury or something like that in the parliament, and they refused to put such questions. They said you have to produce the document first, then only you can. So those practice was not without producing the document. They were not, the defense lawyers were not permitted to cross-examine. So this was subjected to great criticism. And the one view was that produce first, then ask. That was the view. Produce first, then ask. Then the many experts said that will destroy the cross-examiner's right of cross-examination. If the document is produced beforehand, then the witness will be ready with the answers. So that will spoil the cross-examiner's complete right of cross-examination and contradicting. So this was an impact. The way in which that question was prevented by the parliament in the trial was maybe because of the rule still we follow in 144 of the Evidence Act. 144 of the Evidence Act says that before a question is put on certain documents, mostly that covers section 91 documents. If you want to put a question on a document, the document has to be produced first. So that is the rule. Still we have that rule in section 144. So practically section 145 is a departure from the rule contained in 144 that all the documents has to be produced before cross-examination. But as far as a previous statement is concerned, that previous statement need not be produced before the court. So that rule came from this infamous trial of Caroline, and in 1854, UK made the law in their Evidence Act, and in 1865 they clarified it in their CRPC, and US laws they've made as early as in 1870s or something in their Rule 613, Australian Evidence Act Section 55, Indian Evidence Act in 1872 they have made 145. So this is the very interesting aspect of whether the document, the previous statement has to be produced before the court, before the cross-examination. And CRPC or Evidence Act still don't have any rule whether the documents or this type of records has to be produced beforehand. But at the same time, CPC is having a rule, Rule 13, Order 13, Rule 1(3) says that cross-examiner need not produce the documents beforehand. So this is the I could convey what is a contradiction and what is an omission. Now just a few of the rulings, the latest rulings, because all the latest rulings are following 1959 and maybe 1951 onwards. But unfortunately, the most recent ruling that is not reported in any of the leading journals, but that is in the Supreme Court site, Vijay Kumar versus Tamil Nadu. Their neutral citation is INSC 525. No, you need not read that because the judgment is wrong. In that case, what happened was that this very elaborate judgment running into nearly 100 paragraphs. In para 76, in the trial court, the rape victim was confronted by her own previous 154 FIS and elaborately cross-examined, and the cross-examiner has brought out all the inconsistencies and all the contradictions and all the omissions in her 154 FIS. Supreme Court said that is not enough. And the Supreme Court had gone to the extent of saying that 154 is not an encyclopedia. And this is not a 161 statement or 162 statement. So the cross-examiner could have confronted her with her 162 statement or 161 statement, as the case may be, not with her 154 statement. So that is a folly, because as far as the victim is concerned, 154, her 161, not the 161, her 154 FIS is the best document. So if the cross-examiner can bring out all the inconsistencies, contradictions, and omissions in the 154 FIS, that is sufficient to discredit that witness. The cross-examiner need not go any further to 161 or 162 or 164 or any other statement. If you can contradict, that is enough. So that is a mistake committed by the Supreme Court. That is the latest ruling. Yes, rendered 1 month back. And another interesting mistake committed by the Supreme Court was that in the infamous Delhi incident. In Delhi incident, the Supreme Court said the statement, an interview given by a witness to the media cannot be used for the purpose of contradiction. Why? Because that is not a police statement, or that is not a statement during the course of investigation. So that was a mistake, because that also is a previous statement. So that was in NCT versus Mukesh 2014, volume 15, SEC 661. And fortunately, that was overruled in Jasdeep Kaur. I could get only the Manu citation. Manu SC 1324 2017. So that Jasdeep's Kaur clarified that any statement prior to the examination before the court can be used for the purpose of contradicting the witness, which was a mistake. In the NCT versus Mukesh, it was a mistake committed by the Supreme Court by saying that interview given by the witness cannot be used for the purpose of contradiction. That is wrong. And the latest judgment, a very interesting judgment rendered by our Kerala High Court, was by Justice Jayachandra. In that case, a witness was from a common FIR, 3 or 4 rape cases were charged. So the witness in one case, the first case, the witness was loyal to the prosecution. In the other 2 cases, witness turned hostage and gave evidence saving the accused in the other 2 cases. So at that time, she was already cross-examined in the first case. So the cross-examiner in the first case wanted to call her back to produce the other 2 depositions and confront her with those decisions given in the second and third case. That was disallowed by the trial court, and that witness, the defense came before the High Court challenging the trial court order, and the High Court rightly said that that practice cannot be permitted. Why? Because that witness was already examined, cross-examined elaborately, and now the defense wanted to contradict her is with the statements that witness had given in the other case after the entire trial of this case was over, their cross-examination of this case was over. So that was a subsequent statement. That is not a previous statement. So that practice cannot be permitted, and the court disallowed it. And that is a very, very good judgment covering almost all the previous judgments. That is reported in 2025, volume 2, KSC, short note 22. But I don't think that's a short note, because almost all the aspects have been covered. It's a lengthy judgment also. 2025, volume 2, KSC, short note 22. Blusson versus State. But I would say that the defense lawyer could have adopted another method, because the method they wanted or adopted could not be permitted by the statute, also by the precedents, because the time when they wanted to recall the witness, the cross-examination was completely over in this case, and it is not a subsequent statement in the other case. It was not a previous statement as far as the other cases are concerned. Why? Because the other cases she was examined after this case. But the cross-examiner could have used another method. Without mentioning contradicting the witness with the other statement, the cross-examiner could have recalled that witness under section 311. Without mentioning that, he wanted to confront her with the other 2 statements. If the court feels that a further cross-examination necessary, only if the court feels, no doubt. If the court feels that further cross-examination necessary, then that witness will be in the box again. The bar contained in section 145 or 162 is for contradict the witness with a subsequent statement. It is not a previous statement, it's a subsequent statement. So obviously, the cross-examiner cannot put the other statements in the other cases for contradicting the witness, but at the same time, he can put questions regarding the other case without referring to her statements. Cross-examiner can put facts. For example, cross-examiner can say, do you know this B, accused B and C? Have you given a complaint or a statement? Cannot refer a statement. Have you given, do you have any allegations or complaints against B and C? Have you prosecuted them? Do you know the sessions case number? He can also refer the sessions case numbers in the other cases. Have you been examined before that case, before that court? Have you identified those witnesses, those accused before that court? So all these cross-examination are without referring to the statements. The cross-examination is only referring to facts. So if the witness says that, I have seen that witness, if the accused before that court, obviously her deposition speaks otherwise. Her deposition will be to the effect that he is not the person. That was the way in which she must have given statement for turning hostile. If she says that I have not seen that witness, if I have not seen that accused in the other case, then practically she has contradicted. In the sense, she has turned hostile in the same series of cases which arising out of the same crime. So that the defense can say that subsequently she has accepted bribe from the other accused persons and she has turned hostile. But at the same time, if she says that I have identified them, I have prosecuted them, then that other deposition can be produced before this court and this witness can be prosecuted for perjury. So that is a hyper-technical aspect. I'm only saying that there were other methods to get over this cross-examining the witness with the subsequent statement. So there are methods. There are methods which can be adopted for or overlooking the statute and statutory bars. So that is again that is a very hyper-technical, complicated issue regarding the manner in which the trial is to be conducted. So I think I can close now. So this is the contradiction and omissions mentioned in the statute and the precedents. If any questions are there, I'll try to answer.
Thank you, John, sir, for the insightful and enlightening session, sir. Now, I would like to open the question and answer session. Sir, I'll read out the questions from the chat box. So the first question is that how do courts treat omissions that are not outright contradiction but are improvements by the witness? Do they treat improvements with the same suspicion as contradiction, or is there a different standard?
No, because that all depends upon the improvement the witness made. That depends upon the improvement. For example, in the police statement, the witness says, Karinjukondodi. In the court, the witness says, Urake Karinjukondodi. So this Urake, that loudly, he cried loudly, is an embellishment or an improvement. And suppose the prosecution case is that the other witness came to the spot, seeing the cry, hearing the cry, then this is having some importance. Urake Karinjukondodi, this is having some importance because the other witness may be saying that Karichil Gatana Jangal Vanu. So if there is no such situation, this improvement or embellishment has no effect at all. So everything depends upon the facts. So we cannot give a straitjacket formula or answer for that. That depends upon the facts.
Okay.
Not every emotion, not every improvement will amount to contradiction, but some improvement will amount to contradiction.
Okay. So moving on to the next question. If the trial lawyer omits to prove a material contradiction, which is crucial to the case, can the appellate court consider the previous statement?
No.
That's the second question.
No.
Should I repeat it?
No, appellate court cannot. Because that is came before the Supreme Court in a decision 2023. And in that case, there were serious omissions, very serious omissions, which was not proved by the defense. When the matter came before the Supreme Court, obviously the lawyer will ask for a remand. And the lawyer want the Supreme Court to look into. We have the same situation here when we argued in matter before Justice Pradeep. The same question arose. The trial court lawyer maybe forgot or maybe due to his inexperience failed to put very important contradictions. So I want to show that, to tell the court that there are omissions, there are very serious contradictions, though it was not put to the witness. Court may consider that. And Justice Pradeep rightly said that the court cannot. And this was discussed in many judgments from maybe 1952 onwards. And the recent judgment also said that even the Supreme Court cannot look into. But at one point, Supreme Court or the appellate courts can look into for the purpose of deciding whether the matter has to be remitted back or not. Only for that limited purpose. If there are very serious contradictions and those contradictions were not put to the witness, even the Supreme Court cannot look into, but the appellate courts can look into for the limited purpose of deciding whether to be sent back. Why? Because there is a very specific statutory provisions contained in section 162 for the purpose of proving the contradiction. So that cannot be overlooked even by the Supreme Court. And the Supreme Court, all the courts, including the Supreme Court, but mostly it applies to 165 of they would say, mostly applies to the trial court. And the trial court can, in 165 of they would say, put relevant or irrelevant questions. That was the way in which it was drafted in 1872. But in BSA 2023, they have removed the word irrelevant without knowing the consequence of that. The word relevant or irrelevant was inserted in 1872 for the purpose of enabling the court to ask these types of contradictions and omissions to the witnesses. So that has been taken away in BSA. They may think that they might have thought that that is a mistake committed by Stephen in 1872. How can the court put an irrelevant question? There is no such need is there. So they wrongly took away that. So that 165 give that power to the court to put questions, but they cannot contradict the witness in appellate stage. So appellate stage, it cannot be. The only thing is that court can decide on the basis of the contradictions. Court can decide whether the matter requires a remand or not. Otherwise, even the Supreme Court cannot. That is covered in 2023 Supreme Court. Shall give the citation in the one.
Yes, sir. Thank you, sir. So moving on to the next question. Whether omission to state a fact in FIR can be considered as a contradiction during cross-examination?
Yes, obviously. If it is significant and otherwise relevant, it should be significant omission. If it is significant, it can be. Because we have to go back to section 59 Supreme Court 1012. In that, the court has elaborately considered. In that, the omission was like this. A raid was, one party, a group of robbers came there and assaulted, and they shot at 2 or 3 persons and 2 died, if I remember correctly, 2 died. So the omission was that with regard to the presence of a lantern, whether that lantern was present or not, that was the issue. That is one thing. And another aspect was whether the assailants came there and verified the face of one person who was shot. So these are the omissions from the police statement. Maybe from the, I think from the FIS itself. So the trial court said that is not a very significant omission because the lantern was there, whether that the gas lantern or like. So that was a very negligible omission was there. That was not permitted. So if that significant and otherwise relevant, that will be treated as omission and not otherwise. That again, that depends upon the facts of the case.
Thank you, sir. So I'll move on to the last question. To what extent can contradictions and omission in criminal evidence be remedied?
There cannot be a remedy because the problem is that our police officers are not at all trained. That's a big issue. And they will never take the proper statement from any witnesses. And for that, they are also statutorily supported. And section 161 says that if they are making the statement, they can make a true and separate statement. They need not read it over to the witness. In all the statement, they will, at the end of the statement, they will say, "Mozhi vayichu kettu sheri." There is no such requirement. It need not be read over to the witness, and witness need not say that it is correct. Nothing is there in the statute. Why? Because when an incident happens, the police will immediately rush to the spot, because they have to do that if it is a cognizable offense. After recording the statement under 156 CRPC, they have to rush to this place. And the persons coming there will be giving statements. Those statements may not be in the proper way in which the police is recording the statement. They will just say, "ഞാൻ ഓടി വന്നു, അപ്പോൾ കുത്തുന്ന കണ്ടു, അയാൾ കരഞ്ഞുകൊണ്ട് ഓടി." അത്രയൊക്കെ ഉണ്ടാവുള്ള statement. And subsequently, they will sit down and write a longer statement. And in most of the cases, the witness will not be aware what the statement as recorded by the police is produced before the court. So they will be taken on surprise. That is one thing. And whatever be the nature of the witness, how intelligent the witness, the cross-examiner will somehow manage to create contradictions and omissions. So there cannot be any remedy unless the police is properly trained and the witnesses are properly examined and the statement is properly recorded. And there, one more thing, they should be properly tutored before mounting the box. That can be done. There are cases we have seen. There are cases, especially false witnesses. Witnesses who have not seen the incident will give perfect statements because they are completely tutored. They have no pressure from seeing the incident. They are well tutored. That is possible. Barring that, there is no remedy, except the remedy is tutoring.
Thank you, sir. Sir, one last question from the organizers team. What are the significant changes between BSA and Indian Evidence Act regarding contradiction and omissions?
No such significant changes are there. Wherever they touched, they made mistakes. As I already mentioned, the word relevant or irrelevant has been taken away without knowing the importance of that word irrelevant. Irrelevant means, the word irrelevant means refers to the power of the court to put questions on the police statements. That was not that was there. That has been taken away. And in section 123, there is a privilege when we look at the privileged communications. No police officer or magistrate can be compelled to say whence he got information. That was in 1872. Whence means from where. So in 2023, they thought that's a spelling mistake and they made it when. So there's a big difference between the words whence and when. Whence means from where. When means at what point of time. Now, the word is changed from whence to when, which means now the source of information can be asked. Whence means from where. No police officer can be asked from where you got information. That is the importance of the word whence. They removed it. And now they made it when. So now that bar has been taken away. Now the police officer can be compelled to say from where you got information. So that is against the basic principles of privileged communication. Because that cannot be. There may be whistleblowers. There may be persons who don't want to disclose their name. So such persons have to be protected. It is for that purpose in 1872 they wrote whence. Now they say they thought that's a mistake and they made it when. Now that privilege has been taken away. So that is another mistake. And in section 58(6), it's a very interesting blunder committed by the statute. Now we can substitute oral evidence as secondary evidence of a document, which is against all the basic principles. So wherever they touch, it was a mistake.
Thank you, sir. That's the end of the question and answer session. I now invite Advocate Uttara PV to deliver the concluding remarks.
Thank you, Abraham. This was such an interesting and a very enriching session, sir. For a novice like me, for a novice in criminal law, it has been an eye-opener and the light that you have now shed on the fundamentals of criminal practice is so enriching, sir. It's the most invaluable. From this session, sir, has opened our minds to appreciating that the most important task of a criminal practitioner is to identify when a contradiction is to be put to a witness and how or when it can be turned into a fatality. In the slide, sir, I would like to for this very enriching session, I would like to thank you on behalf of ILI and on my personal behalf, sir. I would also like to thank the executive council of the ILI, the president, Justice Jayashankar Nambia sir, and all other committee members, especially thanks to Parvati ma'am and also to Unnikrishan sir, who has been our constant source of inspiration and unwavering support. Additionally, I'd also like to thank all the volunteers who have been supporting and participating in this program. Also, I wish to express my heartfelt gratitude to the President and Executive Committee members of the Kerala High Court Advocates Association for all the support that they've been providing. At last but not the least, I wish to thank the participants and attendees of this event, all senior counsels, advocates, friends, and all students who have been intently listening in and asking their queries. Thank you all.
Thank you.
Thank you, sir.